Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. Here we are again on Tuesday morning here at 10 a.m. This is the Bottled Business Sense show, and I'm Rick Moscoso, one of your co-hosts this morning. As always, I am here with my co-host, Bill Bernard. How you doing, Bill?
I'm doing great, Rick. Thank you. Glad to have everyone back today on this great Tuesday morning at 10 a.m. Pacific Standard Time. We're going to talk again, as we always do, about business protection and business marketing principles that protect your business and hopefully make it prosper during this new year. It's our second show back after the new year. And I think we picked a rather intriguing topic to help our young and old entrepreneurs out there. It's going to be a show that discusses pursuing discrimination and retaliation complaints in the workplace, and it obviously is an employment law issue that really goes into protection category from the standpoint, Rick, that while this may seem to be a show that helps employees or guides employees down a path of knowledge in terms of any problems they may be having in the workplace, and indeed it is, it's also a guide as to what employers can do to make sure that certain things in the workplace don't occur. And I'm going to point out some things along the way, some extra tips for employers to follow as well to make sure that these types of complaints of discrimination and retaliation don't occur.
Awesome. Well, folks, if you are a first-time viewer or a listener here on the show, and as we go through the information, as Bill talks about the topic today, if you have any questions, feel free to drop us an email at bottledbusinesssenseshow@gmail.com, and Bill will respond just as soon as he can in regards to your questions. So with that being said, our topic, as Bill had said, is pursuing discrimination and retaliation claims, and where do we start from there, Bill?
Well, let's start by indicating that in order to file, we're going to talk about a series of very specific steps that will help put this in perspective for you. But before we do that, let's make sure we all understand that in order to do what I'm about to describe today, you must have been discriminated against or retaliated against based on a protected characteristic. Okay? And we're going to talk about what those protected characteristics are. But again, there must be discrimination against you, or some employer or someone at your place of employment must have, in a position of power over you, must have retaliated against you for bringing a claim of discrimination or for standing up for someone else who's brought a claim for discrimination. So let's talk, first of all, before we get into what the protected characteristics are, let's talk about the federal and state agencies involved. And the first one would be a federal agency called the Equal Employment Opportunity Commission, better known in short for EEOC. The EEOC employs investigators to investigate claims of discrimination, which again we will get into shortly. The state agency that is also covers the same type of claims would be the Department of Fair Employment and Housing, and the in short called the DFEH. DFEH. So we're going to be dealing with the EEOC from the federal standpoint and the DFEH from the California state standpoint. And the DFEH has what they call consultants who look into claims of discrimination. So the EEOC has investigators and the DFEH has consultants. Let's get a little bit into the laws that both of these agencies enforce. Very important. The EEOC enforces the following federal laws, which are under Title VII of the Civil Rights Act. Discrimination based on race, color, creed, natural origin, or sex. So any of those would be your protected characteristics that we spoke of at the top of the show, Rick. It also protects against the ADA, or better known as the Americans with Disabilities Act, which prevents, having a tough time talking here today, prevents discrimination based on physical or mental disabilities. The EEOC also prevents discrimination pursuant to the Equal Pay Act, or the EPA. That prohibits paying one gender less than the other for working for the same required skill, effort, and responsibility. So let's leave the EPA out for a second, because you normally that's going to be that can be brought in as well as under a discrimination claim. In contrast, the Department of Fair Employment and Housing, or DFEH, enforces the Fair Employment and Housing Act, which prohibits discrimination based on race, color, creed, national origin, ancestry, sex, age, disability, medical condition, genetics, sexual orientation, and gender identity. So, in a mouthful, that's a lot of stuff. The DFEH state and the EEOC federal prohibit the same types of discrimination, and I've described those because you are in a protected class. If you're discriminated against in one of those areas, one of those protected classes, then you can bring either a federal claim or a state claim, or both.
So,
okay?
Bill, these two agencies and the guidelines that they list here, how is an employee knowledgeable about the contents of this? Is there something that's mandated for every employer to inform a prospective employee or a newly hired employee of this information?
Yes, an employer must have posted in his workplace at a place of visibility for all employees a poster that identifies the specific rights for which the rights they have and for which they are protected. And normally a good employer, as a matter of fact, one who is sharp and who is into protecting his business, and this is a good point, Rick, will have, and I've done many of these, will have an employee handbook, a very, very thick, well-detailed employee handbook that an employee will get upon coming to the job, that he or she will sign for and acknowledge the receipt of, and is expected to know the contents of. And in that employee handbook as well will be provisions outlining the prevention of discrimination and retaliation in the workplace.
Okay.
So now, having said that, let's go from discrimination to retaliation. Okay. All the laws that we've just talked about contained in the discrimination protection, either DFEH or EEOC, are also protected by way of charges of retaliation. So you can be retaliated against in the following ways. One, if you filed or threatened to file a charge or complaint with the EEOC or DFEH that we just discussed. So now you're filing not only a discrimination claim, but now you're being retaliated against by your employer for doing so. That might be proven by circumstantial evidence. In other words, something that's continually happening to you that's getting worse now that you filed this complaint, or it may be directly, which doesn't happen very often, where an employer may say, hey, you want to file a claim against me? I'll show you. That doesn't happen very often. Number two, you can be retaliated against if you've complained about discrimination at the workplace and nothing's happened. And as a consequence of your complaint, and say to your boss or to your employer, hey, let's do something about this, again, now you've started to be treated more harshly or more discriminatorily. Number 3, if you've participated in any investigation related to either your claim or someone else's claim, you're helping someone else, or you're assisting the EEOC or the DFEH in its investigation of your claim, and then you're retaliated against. Or finally, number 4, if you've been associated with someone against who an employer wants to discriminate, and that employer knows that you're his or her friend, then bad things all of a sudden start happening to you. So retaliation is kind of self-explanatory, Rick. It means if you've got what you believe to be a legitimate claim against your employer, and now you're being retaliated against because of it, that's a separate claim from the discrimination claim itself.
So how would one protect themselves from this and not be caught in a situation where it's he said, she said type of thing, where your credibility is really not so much in question, but it's like, okay, the burden's on you to prove what you're claiming.
Well, if from an employee's standpoint, if they have witnesses, that's always going to be helpful. Or if they can prove whatever's happening to them by way of documentary evidence that may be in the employer's control. From an employer's standpoint, an employer always wants to have a complaining employee, always wants to have a conversation with that complaining employee with someone else present, someone else at the place of employment who can substantiate and witness what is being said, because there have been cases where employees decide to make up things later on and all of a sudden provide inconsistencies to what they originally complained about, or kind of like to spice it up a little bit or add on to it. So you always have witnesses present if possible, and you always document every meeting you have with such an employee. Even if that employee is not making a complaint of discrimination or retaliation, I would document every conversation that I have on a one-to-one level with an employee concerning a work-related issue. Okay? It's not any big deal. After the employee leaves, you just simply make a note, and I would have in my top drawer a drop-down file with each employee's name on it, and then when I have pertinent business discussions with them, I make a little note, I drop it in the drop file on that employee, whether it's good, bad, or indifferent. How does that also help you, Rick? Well, that helps you at the end of the year. When you go to do an employee evaluation, you pull out that drop file, you've got notations on the employee's performance during the year, you convert it into an annual evaluation, and now you've got your substantiation for that employee's performance should you have to fire that employee, or should that employee come back and make a claim of retaliation or even discrimination. You may have a basis in that file to substantiate whatever action you took against that employee, which would negate a claim of discrimination or retaliation. So document everything.
Mm-hmm. Are there business out? I'm just curious. Are there businesses out there that have gotten to the practice of videotaping their interactions like this?
Not that I'm aware of. No. And normally if you're going to videotape somebody, you would make that very pertinent, make that very clear at the beginning of the job that such things might occur in case it would ever want to be challenged by that employee, or you would do it by getting the employee's permission at the time you're going to do it and say, can I do it? And the employee can say yes or no. There's no strict hard and fast rule against that. Some employers may even decide to do it without the employee's permission. But I'm always the kind of person that wants to be on the level on the up front, and I would indicate that because of the fact that it's a little bit unusual. I would want to indicate that to the employee either up front before he or she is hired, or before I decide to do it at a particular point in time when I meet with that employee. And the employee may understand. The employee may say, I feel uncomfortable, and the employer may decide to do it anyway, or the employee or the employer may say, well, fine, if you feel uncomfortable, we won't go forward with the videotaping. So, it wouldn't surprise me that somewhere down the line, if it was done without the employee's permission, it could try to be challenged. Much in the same way that other types of things that aren't brought to the employee's attention at the forefront of his or her employment are challenged. But I don't think a video would have as much problem being sustained at the end. It's just that I think you want to be upfront with the employee.
Yeah, that makes sense. Yeah.
It just does. You want to be, if you're really going to handle these things on an up and up manner, if you're going to be on the level, be not only courteous and respectful, but be straightforward with your employee. Never take the low road, always take the high road. Even if you suspect an employee trying to make a bogus claim, you take the high road. Now let's talk a little bit about employers that are covered. Okay, we've talked about discriminatory, what is discrimination, what is retaliation. We've talked about the various agencies, state and federal, that investigate those. But what employers are covered? Well, as far as the EEOC is concerned, in order to enforce Title VII and the Americans with Disabilities Act that we spoke at the forefront of the show, the EEOC will investigate employers having at least 15 employees, okay? And as far as that would be for Title VII, for sex, race, age, discrimination, national origin, creed, that sort of thing. The Americans with Disabilities Act would cover employees, the EPA that we spoke of earlier, the Equal Protection Act for pay, would cover employers with at least 2 employees. So as again, that's a particular kind of a notion or an act that I'd rather hold off in abeyance a little bit, because there's a lot to cover here with the discrimination and retaliation. So for federal purposes, 15 employees or more, the EEOC is going to have jurisdiction over. For the DFEH, the state, any employer with at least 5 employees or more are covered with respects to acts of discrimination, retaliation, unlawful harassment, that sort of thing. So easy way to remember: federal law, 15 employees or more; state law, 5 employees or more. Okay.
Excellent.
Now this could become critical, Rick, for let's see, how should we put this? Because this brings an interesting subject to bear. An employer may decide to keep down the number of employees in his business for reasons that we've just mentioned. Doesn't necessarily mean you can get away with acts of discrimination, okay, necessarily. But we would hope that employers would be, again, on the up and up, and not have in the back of their mind, wow, I can do underhanded things because I'm not meeting the employee minimum for these particular acts, both state and federal. Mm. So I would hope that wouldn't occur. There's strange things that happen all the time, I know, but if I'm an employee and I'm in a position with a company that might not cover discrimination claims by the EEOC or the DFEH, that doesn't mean that I'm not going to bring a claim for discrimination if one should occur in the workplace. Okay, remember that the DFEH and the EEOC investigate claims before you have to file litigation. It doesn't mean that without them you still can't file litigation, and that's what we're going to get into here as we get to the bottom half of the show.
Great. Well, this is fascinating stuff, and I think it's going to be extremely helpful for people as they transition, go into a new workplace this year, or they're caught in a situation like this, an unfortunate situation like this. But before we get into the back half of the show and learn more about what you have to share, we have a new sponsor we want to talk about today, and that is Mr. Jack Aubuchon of Mission Coast Insurance Services. Yes, and
Jack's kind of a unique kind of a guy. He handles all kinds of insurance that we wholeheartedly recommend people have. He has the general liability policies. He has workers' compensation, which of course employers who have employees need in case there's an injury on the job. You can't sue your employer. You have to go obtain workers' compensation relief, and that employer has to have workers' compensation insurance. Professional liability insurance for professions such as myself, which would be malpractice insurance. He handles commercial auto. He handles commercial property. So all of these types of critically needed insurance coverage is provided by Jack. Now, why Jack? Well, because Jack's an independent agent. We know him. We have vetted him. We trust him. We recommend him, number one. Number two, he's an independent agent, so he's going to be able to shop around and get the best price for you in terms of what you can afford and what would suit your company the best. So Jack at Mission Coast Insurance Services, you can get in touch with him at jack@missioncoastinsurance.com, and his phone number is 949 area code 305-3076. Jack Aubuchon, and that is spelled Aubuchon, Jack Aubuchon at Mission Coast Insurance Services, missioncoastinsurance.com. Okay?
Excellent, excellent.
Okay, I wanted to just take a moment to bring our viewers up to speed on the distinction between discrimination and harassment, okay, because that comes up a lot. We've been talking about all these kinds of discrimination. What's the difference? Well, you bring a claim of discrimination against the employer, okay? You bring a claim of harassment against a person who might be in a position of power over you, who also works for your employer. So in other words, let's say that you're being harassed by a particular person at a company where you're employed. This person is someone who is your supervisor. You can bring the claim against your employer. You can bring a claim against the supervisor as well. Your essential claim against the employer most oftentimes is the employer knew or should have known about the harassment from the supervisor but did nothing about it. So in other words, this employer just said, I'm just going to look the other way. You can also bring a claim of harassment against an employee who is harassing you, another employee, on the job, and then you bring a claim, you bring a complaint to the Human Resources Department within your employer's company, and you let them know about this harassing behavior. You're tired of it, you want it to stop, and then they don't do anything about it. You bring a claim of discrimination if it's a discriminatory in the discriminatory context that we mentioned at the top of the show: race, age, creed, color, sexual origin, sexual preference. I'm sorry. And then you bring a claim of harassment against that employee as well. So there are creative ways to do this. I would suggest you see a lawyer with regard to your particular circumstances. But remember, if you're the employer now, if you get wind of this, you do something about it. You sit this person down, you tell them this stuff has to stop, you verbally reprimand them, or you write them up, written reprimand. You follow the guidelines that are set down in your employee manual, and that should be done for you by an attorney as well. So it spells out clearly how forms of reprimands are going to occur and on what level they will occur. They get worse each time until eventually it may end up to where one employee is terminated. And if you have to do that right off the bat, if the act is egregious enough, then you have to do that too, and then you document that as an employer.
Okay. Well, let me throw a little twist in there.
Sure.
In the form of a question. So let's say I'm a solopreneur and I contract people to do various things in addition to what I do as the solopreneur, and they're paid via a 1099.
An independent contractor.
Yeah, an independent contractor. So in that case, what recourse does that, if let's say something egregious happens, right?
Sure.
What does that contractor, what resources does he have?
Normally, you mean if the contractor is the guy who's acting in a discriminatory manner?
Well, let's say the guy that hired the contractor is acting inappropriately. And
toward the contractor.
Toward the contractor.
Well, the contractor is not an employee, so generally the contractor is not going to bring a complaint in the normal method against the employer because he's a independent contractor. But it doesn't mean that he can't fashion another type of claim against the employee. Well, the employer. We're calling him an employer, but in actuality, he's the principal, and the independent contractor is the agent, because there's not an employer-employee relationship. Mm-hmm. So in that instance, if the independent contractor is suffering from discriminatory behavior, normally he would see a lawyer and he would try to fashion a cause of action against the employer, if possible, in some other mode, some other type of civil action, which could result in, it could be defamation, it could be some claim that he's being discriminated against. However, that discrimination is going to have to be have to be fashioned in a form that allows that independent contractor to try to say that he is being treated like an employee rather than as an independent contractor, because that independent contractor always has the right to just leave and not work for that employer anymore if he feels he's being mistreated. Because these acts are really intent and bound on covering employer-employee relationships. So if an independent contractor can fashion a claim such that he can be considered an independent contractor and an employee, if he can make a claim that really, hey, I'm an employee, despite my 1099 payment form, then he might be able to suffice. Otherwise, he's going to have to fashion another cause of action that's based in tort, and he's going to have to go on his way and move on down the line.
Yeah. Okay. All right.
Okay. Now, let's talk about what this complaint is called. The EEOC, when you file a claim with the federal government, they accept what is called charges of discrimination in California, and they will accept charges of discrimination up to 300 days from the date of the last discriminatory act. So let's say you're getting discriminated against, and it's over a series of a period of time and a series of different acts. Well, the last act, let's say the last act is your termination. Okay? You would have 300 days from the date of that termination to file your charge or your charge complaint with the EEOC. With the DFEH, okay, if you discover discrimination more than 1 year after it has occurred, then you're going to be in a bit of a pickle, and you're going to have to try to get a 3-month extension, which I'm not interested in talking about here today. What I do want to say is you have a year with the DFEH from the date of the last discriminatory act. Remember that the last discriminatory act, discrimination may all of a sudden stop in the workplace, and you may want to still file a lawsuit. That last discriminatory act could be an act itself, or it could be the act of termination. It could be a number of different things. So that's why you're going to want to get help from a lawyer to make that determination if you have some problem distinguishing it on your own.
So in your experience, why would somebody wait that long if it was something blatantly wrong that they wanted to complain about? Why would they wait?
Oh, that's an easy question to answer, Rick. Candidly, a lot of people are afraid. They don't want their job to get worse. It's sort of like if you ever see someone who's accused of beating their spouse, and the spouse keeps coming back to the person, and the law can't understand why. Well, I'm not going to press charges. The person's going to change. It's going to be the end, and then they get beaten again. It's a fear of going out on your own, tackling a new lifestyle, finding a new job. It's the hope that maybe your job is going to get better, just like you feel the spouse is going to get better. It's a fear of loving your job and having to stay on the job, feeling like it's going to get worse if you make a claim. There's all kinds of things that occur. It could even be where you think that the discriminatory actions have stopped, and you see things getting better for a while, and now all of a sudden they start up again. So it could be a whole slew of reasons why somebody would wait a period of time before filing a claim with the EEOC or the DFEH.
Okay.
So now let's talk about the fact that you filed your claim, okay? And now how do you bring a lawsuit? Well, the DFEH and the EEOC will issue what are called right to sue letters, okay? And when you get a right to sue letter, that means you can then file your lawsuit in court. Okay, so if you file your charge of discrimination with the EEOC will normally mail the DFEH a right to sue letter, okay, which is hidden inside your packet, so you have to look for it from the EEOC. And then when the EEOC has finished investigating your charge, they will issue you a right to sue letter. When the right to sue letter is issued by the by the EEOC, you then have 90 days to file your lawsuit. If you don't file a claim with the EEOC, but rather you file it with the DFEH, the state agency, you have 1 year to file your lawsuit after you receive the right to sue letter from the DFEH. Okay? So 90 days after you receive a right to sue letter from the EEOC, 1 year after you receive the right to sue letter from the DFEH, which is a state agency in California. Something that's important to point out, Rick, is when you file these claims with the EEOC or the DFEH, you can have them investigate. And I think everybody's thinking, well, that's what I thought what this show was all about. But if you can choose to say, no, I just want to file my claim and now I want to sue. And they will immediately issue a right to sue letter without doing an investigation, either one of these agencies. In other words, this is a precursor. For a discrimination or retaliation claim under federal and state law, you must file a claim against the employer by way of the EEOC, federal, DFEH, state. But once you file it and you fulfilled those mandates, you can then say, I don't want you, DFEH, I don't want you, EEOC, to do your own investigation. Just issue me a right to sue letter so I can proceed with my lawsuit, and they will be happy to do so.
Now, why would they forego any investigation?
Because they give up their right to do that by allowing you to proceed with the lawsuit, at which time, during the lawsuit, all of the evidence is going to come out.
Okay.
They could do their own investigation, and if they do their own investigation, if you don't ask them to give up that right and they do their own investigation, they could do a couple of things. They could issue a ruling that they found discriminatory conduct. They can issue a ruling that they found no discriminatory conduct. You're still going to get your right to sue letter, and then you can still proceed with your lawsuit regardless of their findings. Or they can say, this is so egregious, we're going to sue your employer. And then they can file their own lawsuit. But if you say to them at the beginning, I filed my claim, Mr. EEOC, and I filed my claim, Mr. DFEH, and I do not want to pursue, I do not want to wait for your investigation, issue me my right to sue letter, they will do so, and then nothing happens except you are given the opportunity to then file your lawsuit.
So if they did, these two organizations did their investigation and they established a certain ruling, it wouldn't necessarily supersede the decision that comes out of a lawsuit, would it? Or prior to going into a lawsuit?
You mean if the EEOC and the DFEH issued a ruling?
Yeah.
No. Has nothing to do with you filing the lawsuit. There may be some evidentiary issues, which this show is not, though, is far too short to get into, as to whether or not those rulings will come into evidence, but that has nothing to do with whether you can then proceed with your own lawsuit. Once the DFEH is finished with their investigation, once the EEOC is finished with their investigation, you can then bring your own lawsuit, period, end of story. Again, remember, I don't want to confuse anybody on this, you do not have to file with both agencies. You can file with the DFEH, you can file with the, I have a action right now where the individual filed a claim with the DFEH, did not file a claim with the EEOC. the individual asked for an immediate right to sue letter, and now the individual has 1 year from the issuing of the right to sue letter on December 5th, 1 year from December 5th, to bring the lawsuit against the parties in question. Okay, so this is important stuff. I just wanted you to point out these highlights to you, because these are things that you need to know as an employee, but you also need to know as an employer. You need to know what limitations the employee has when they file their claims, what their statute of limitations is once the right to sue letter is issued. But even more importantly, you need to know that to prevent these types of activities, make sure you have a plan in place where you have an HR department that takes complaints by employees, that if the employee's claim is not legitimate in your opinion, speak to a lawyer, confirm that, document everything. If it is legitimate, make sure you take corrective action immediately, and please never try to do anything. And this is where, again, I would speak to a lawyer if you have any hesitancy in what to do next. Make sure, if the claim is legitimate, or even if it isn't, that you don't take future action that the employee could then claim as retaliation against him or her. You need to sort this stuff out with a lawyer, and that can be very helpful from the very beginning if you have a lawyer that you can bring on board that will do an employee handbook that will fashion the process in the handbook, because once that employee signs it at the beginning of his or her employment, they are claiming that they received it, and you can fashion language in that receipt that they signed that requires them to read it. Whether they actually read it or not is not your problem. Once they sign off on it, if the appropriate language is there, you can say you signed it and you received it and you were expected to read it and know it. You can't claim later on that you don't know what the process is. Yeah. Because you don't want to have a process or a procedural claim being made by an employee on top of whatever substantive claim they may have for discrimination.
Right, right. Well, employers, protect yourself. Employees, get somebody. If you run into a situation like this, make sure you get the appropriate legal counsel, and a guy like Bill can certainly help you out in this type of situation. He's an expert in his field in regards to employment law, and if you have any questions in regards to the topic today, Bill, how would someone? What's the best way for someone to get a hold of you to contact you?
They can get a hold of me at bill@wfblegalconsulting.com, or at the following phone numbers: 949-413-6535 or 949-698-6222. I just want to take one moment, Rick, to recap. Make sure, whether you're an employee or an employer, you supply a chronology of important events that occur with your employee. If you're an employer, you mark down meetings, you take notes, you drop it in your drop file. If you're an employee, you make a chronology, you keep a diary of everything that's happening to you at the workplace that you think is inappropriate. Secondly, you prepare a list of witnesses who can verify the facts of your case, whether you're an employer or an employee. No matter what side you're on, you make sure you have a list of people who can speak to the issues at hand. And third, you complete a list of all documents that might be helpful to your cause, whether you're an employee or an employer. If you have documentary evidence that'll be helpful to your position, make sure you take care of that and know where it is and have access to it. And I think that should be more than sufficient to make sure you cover all the bases. So I hope that again is helpful. I hope that people, both from an employer and employee standpoint, take notice of this, and make sure that you're a step ahead of the game. Stop it before it happens. If you're an employer and you sense something going on, or somebody makes a complaint against you, and if you're an employee, don't wait. Don't drag it out, because it becomes more difficult to lend credence to the longer you wait. When something happens to you in the workplace, make it known to your employer ASAP. Okay?
Yeah, excellent. Well, folks, again, Bill's the guy to talk to. His contact information is below this video here. I'd be happy to discuss with you any issues that you have in regards to employment law. and the topic today. So, Bill, excellent show. I mean, I learned a lot today. I learned how to not to get in a situation like this.
Well, you know, we talked a while back, Rick, on one of our shows about, we touched upon some of this stuff, and I kept promising. I said I'm going to do a show on the DFEH and the EEOC and some of these agencies that you need to be aware of, and we kept dragging it out quite candidly because we had a lot of other interesting issues people were concerned about, and I figured at the top of the year it would probably be an appropriate subject to discuss because we do have businesses that are following our plan that are growing with us. Mm-hmm. And as they grow, they're going to add employees, and they're going to now all of a sudden have to be aware of things that maybe as a solopreneur they weren't necessarily aware of previously. So that's why we did it, and I hope it's helpful to everybody.
Yeah, well, that's awesome. So, folks, thank you again for being here in this episode of the Bottle Business Sense Show. I am Rick Moscoso, and on behalf of Bill Bernard, my co-host on the other side there, we look forward to seeing you again on our next show next Tuesday at 10 a.m., same place, same time, same bat channel, right?
You got it. And your sense of humor never goes by the wayside, Rick. Okay. No, we appreciate it, everybody. Take care. Have a prosperous week, and we'll see you next time, okay?
All right. Bye-bye, everyone.
Bye-bye now.